and recognize myself for 5 minutes. I just want to talk about a couple of things that have already been said. Congressman Stanton and I carefully crafted the legislation to ensure that there is no exploitable loopholes, which I think some of the members who have been critical, you've got old information. And, you know, you should talk to your colleague, Congressman Stanton, about kind of what we did and where we went. It's accomplished by employing, there's a two-pronged test for the ATF to consider when determining whether a product submitted for classification is truly a less than lethal projectile device. In the first test, an objective test, the ATF would evaluate whether the product submitted for classification is designed or intended to expel a projectile at a velocity exceeding 500 feet per second. Because the technology is changing. 2 years ago, you're talking about 2 years ago? The technology has advanced significantly since then. And the second subjective test would give the ATF the ability to determine whether the product is designed or intended to be used in a manner that is not likely to cause death or serious bodily injury. And this is what law enforcement has been requesting. This prong ensures that even in a device that fires a projectile at 499 feet or lower is created, ATF can still step in and classify the device as a firearm. So we were very careful. I mean, Congressman Stanton and I looked through this and said, what are the things we could certainly work on to make this comply with the Gun Control Act? So the other thing I just wanted to talk about is the changing of the firearm classification. So the ATF, they have a very robust and thorough classification process to determine kind of whether a product is a firearm under the Gun Control Act or National Firearms Act. Because there's other things that law enforcement uses that fall into a different category. And the request for a classification determination, they're required to be submitted to ATF under the regular penalties and must include all the relevant parts and accessories that are part of that. So under the text on HR 3269, any product submitted to ATF for classification will be scrutinized under ATF's existing classification process. ATF retains its full authority to regulate a device as a firearm unless both the objective and subjective prongs of the HR 3269 test are fully satisfied. So this bill does not disturb ATF's right to rescind a prior classification determination or request that a device be reevaluated under newly implemented regulations or if there's any significant changes to how the product is used by the public. So I once again, I mean, I know that, there may be some concerns and I was under the impression that Congressman Stanton had talked to many of the members who may have had concerns about, where we were in previous bills. But I still think the bill that is before us today makes a lot of sense. It's going to help law enforcement. They're asking for it. I certainly think that HR 3269, if you look at it, this is state-of-the-art, less than lethal technology that's currently available. And that's why law enforcement is asking for it. There are situations in some states, which I mentioned earlier, where, without this bill, it still ties the hands of law enforcement when it comes to liability. So once again, I would urge people to support the bill. I think it makes a lot of sense, and I think Congressman Stanton has done a good job in being a good author that's been very diligent in the way this is worded. So,
Would the gentleman
I yield back.